Student, here is next video from the chapter of offer and acceptance. Today's video is about the revocation of offer, and I will provide you information about the revocation offer from the section 6 of the Contract Act 1872. There are multiple modes regarding the revocation of offer. A revocation offer also stated with the end of offer as well as termination of offer. So very first mode which is on your screen, that is notice of revocation. When a proposal a proposal can be cancelled or revoked by sending a notice of revocation to the other party, and you know other party is offeree. You can say offerer may cancel his offer at any time before the offeree has communicated his acceptance. In short words, before the acceptance of offer, offerer can cancel his offer anytime. So, the offerer can reject the offer before its acceptance, even though the period for which the offer was kept open has not yet expired. In this way, no contract would arise because the offeree cannot create a contract by accepting the revoked offer. For the clarification of this first mode, here comes the example. A at auction sale makes the highest bid to buy B's goods. He withdraws the bid before the fall of hammer. So he can cancel his offer before the fall of hammer. The fall of hammer means here the acceptance. So you can say the offer is revoked before the fall of hammer. The next mode is lapse of time. When the offer is kept open until a particular date, it terminates if it is not accepted by that time. So you can say the offer does not specify time. If no specific time is mentioned in offer, it terminates after the lapse of a reasonable time. So where there no time is specified, students, in offer by the offerer, that offer automatically cancels or terminates on the expiry of a reasonable time. Question here is, what is reasonable time? It depends on circumstances of each situation and case. If the commodity for which offer is made is perishable in nature, then the reasonable time will be shorter comparatively. The next one is failure to fulfill condition. It's a third mode of revocation of offer. Students, offer is revoked if the offeree fails to fulfill the conditions given in it. You can say if an offer contains some conditions which are positive in nature and the offeree has not taken responsibility to fulfill such conditions. I am repeating my words. If certain conditions are mentioned in offer and on the other side offeree is not taking the responsibility to fulfill such conditions, so on the non-fulfillment of conditions by the offeree, offer would be considered cancelled or revoked. The next one is death or insanity of offerer. It's a very important situation for the cancellation of offer. Offer is revoked by the death or insanity of the offerer if the fact of his death or insanity comes to the knowledge of the offeree before acceptance. So here acceptance is important. If death or insanity takes place before the acceptance, the offer would be considered as revoked or cancelled. On the other side, if the offeree has accepted the offer and then death takes place or insanity takes place, then the legal representative of deceased person or insane person would be responsible to complete the obligations of contract. Dear students, the next one is revocation of offer by the offeree. Here, offeree rejects the offer and communicates the rejection to the offerer. The offer shall terminate, even though the period for which offer was kept open may not have yet expired. The rejection by the offeree will revoke the offer, and this rejection may be expressed or may be implied. The next one is counter offer by offeree. So very important mode of revocation. An offer may be revoked by the offeree by making the counter offer. When an offer is accepted with some changes in terms of the offer. I am repeating my words. When an offer is accepted with some changes in terms of offer, such acceptance is called counter offer. If a party making a counter offer wants to accept the original offer, he cannot treat the offer as still open. An offer once rejected cannot be renewed. So, an offer once rejected cannot be renewed. Students, next one is subsequent illegality. Offer lapses, offer cancels if it becomes illegal before its acceptance. So mind it, before acceptance. So you can say offer may also terminate when it becomes illegal due to change in law before its acceptance by the offeree. So the next one is destruction in the subject matter. Offer comes to an end if the subject matter, means for which offer is made, destroys before acceptance from the other party. Student, here comes the 10th one. It is failure to accept according to the mode. You can say if offeree fails to accept the offer according to the mode prescribed in offer, the offer considered revoked. If offeree accepts not accordingly, offerer must reject such acceptance, otherwise he is deemed to have accepted the acceptance. Last line I am going to repeat once again for your more understanding, students. Offerer must reject such acceptance where acceptance given not according to the prescribed mode by the offeree. Otherwise, the offerer is deemed to have accepted the acceptance. So students, this is all about the revocation of offer according to the Contract Act 1872. Lots more videos from business law you will get in the coming time. So see you inshallah. Goodbye.